In this video, we delve into the potential impact of revoking CHNV parole for Cuban nationals in the United States. We will explore key aspects such as the Cuban Adjustment Act and how it relates to applying for residency. Today, our agenda will cover 5 main areas: the Cuban Adjustment Act, the difference between parole and residency applications, potential delays, legal challenges, and eligibility requirements for residency. Let's quickly consider the key points we've touched on. The Cuban Adjustment Act is a valid pathway to residency. Parole, while allowing a legal stay, is separate from the residency process. Potential revocation could delay applications, and such changes are likely to face legal challenges. Lastly, eligibility for residency requires a year of physical presence in the U.S. The Cuban Adjustment Act is a critical legal pathway for Cubans aiming for permanent residency. Despite potential changes in parole status, as long as Cubans meet the criteria outlined in the CAA, they can still apply for an adjustment of status. The CAA remains unchanged by parole process alterations. It requires applicants to have been physically present in the U.S. for a minimum of 1 year, among other criteria. Let's distinguish between parole and residency. Parole allows a Cuban national to temporarily stay in the United States legally. However, residency applications are managed separately, specifically through the Cuban Adjustment Act. Even if parole is revoked, as long as the Cuban national meets certain requirements, they can apply for residency. The ability to apply for residency is not directly influenced by parole status changes. Let's take a quick quiz break. What remains a possible legal pathway to residency for Cubans, even if CHNV parole is revoked? A. Parole. B. Cuban Adjustment Act. CAA. C. Visa Waiver Program. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. If you answered B. Cuban Adjustment Act, CAA, you are correct. Despite changes in parole status, the CAA remains a solid pathway for Cubans who meet the set criteria to apply for residency. With potential changes to policies, applications from those who entered under CHNV parole might face processing delays. This can cause uncertainty for those awaiting residency decisions. Changes often lead to shifts in administrative procedures, slowing down the process. It's important to note that any revocation of parole may face legal challenges in court. These legal fights help to ensure that any changes in policy regarding parole are closely scrutinized and are both stable and fair. To meet the requirements for residency under the CAA, Cuban applicants should have been physically present in the U.S. for at least 1 year. They must also satisfy other criteria specified by the CAA. Staying updated with policy changes is crucial. Consulting an immigration attorney can provide personalized advice tailored to individual situations. In summary, the Cuban Adjustment Act remains an active pathway for residency applications from Cubans. Changes in parole alone do not affect the eligibility for residency if CAA requirements are met. However, potential delays and legal challenges could affect processing times. Staying informed and consulting with legal professionals will help in navigating these complexities. Thank you for watching our deep dive into the revocation of CHNV parole for Cubans. We hope you found this information helpful. Please like, share, and subscribe for more content. And feel free to share your thoughts in the comments below.